Good evening, everyone. My name is Carrie. I'm the organizing director here at FairVote Washington, and we're so excited to welcome you to the November Roadmap to Ranked Choice Voting webinar. I'm so excited for you all to meet tonight two very special guests. We have David Daley, who is a national expert on gerrymandering and electoral reform, as well as David Morales, who is a really strong community advocate, as well as legal professional here in Washington State. But before we get into that conversation, I just want to lay out a little bit of what you can expect tonight. First, you'll be able to hear from Elise, our executive director. We'll have our conversation. There's, of course, opportunities for Q&A towards the end of our panel questions. Please put them in the Q&A function in Zoom. And beyond that, we're really excited to have you here tonight. So with that, I'm going to welcome Elise to chat with you all.
Thanks, Carrie. Thanks, everyone, for joining us. It's great to get our roadmaps restarted after a few months away. So thank you all for joining us tonight. I want to start off with a few updates from FairVote Washington. As you know, in the next few years, we are really focused on getting more local jurisdictions using ranked choice voting. And there's a few ways for us to do that. One is to get more champions in office at the municipal level. So thank you to everyone who volunteered your time with FairVote Washington PAC over the last 6 months or so during the primary and then general elections. We endorsed over 200 candidates in the general election. We are still watching the results trickle in. Some of them are likely to take a while when you consider recounts and the like, but we're really happy with seeing dozens of new democracy champions in office across the state. Some of these races were decided by extremely slim margins. So to all of you who spent your time knocking doors or calling or texting voters, those communications really did make a difference. So thank you, and look forward to a recap of the race that have been called around midway through this week. Now, still a lot of cities across the state that even if we have those champions in office, they don't have the legal ability to use ranked choice voting, even if they and their voters want to. You all know this. So you know that we are working to bring that local option across the state, and we are going to continue doing that in the legislative session, which starts in early January. I am really happy to announce that for the second year in a row, our coalition partners have named ranked choice voting, the local options work, as one of their priorities for the legislative session. And because of that, we are actually combining this year's lobby day with our partners at the Washington Voting Justice Coalition, which means this will be our biggest lobby day yet and a chance to make new friends across the democracy community and make a really big splash on the campus in Olympia with hundreds of democracy supporters all there at the same time. I really hope you'll consider joining us. It's on a Friday this year, and it's RCV Day, January 23rd. So I think this is going to be our biggest and best lobby day yet. And I hope you will all consider joining us. The registration link is in the chat. We are definitely going to be telling you more about our strategy this year and some other legislation that we are endorsing in future roadmaps. So make sure you tune into those later in November and then in December. And then finally, since some of our most ardent supporters and volunteers are here tonight, I want to give you all a really special update on staffing here at FairVote Washington. We have a new organizer who will be starting 1 week from today. Her name is Root, and she is incredibly talented as an organizer. She also has a computer science background, so we know she'll get along with a lot of you. And I'm really looking forward to you getting to know her. I think she is going to bring incredible skills to our team. We don't have an email set up for her yet, but if you want to give her sort of a welcome, I'd encourage you to email Carrie with a message for Root, and she will forward it to Root on her first day. So that information is also going in the chat. It's a nice way to welcome this new member of our team. All right, those are the updates from me. I'll hand it back to Carrie now.
Thanks so much, Elise. Uh, It was, we are very excited to bring Ruth on board. I think you are all going to love her as much as we already do. So appreciate that. Oops. Next, of course, we'll get into our panel. We are, of course, talking about the United States Supreme Court case, Louisiana v. Callais, which is a court case that will deeply potentially impact our Voting Rights Act, and you'll hear a lot more of that from our panelists today. So I will go ahead and get on with it and introduce our first panelist, David Daley. David Daley is one of the nation's leading experts on redistricting and voting rights. He is the author of 3 books, including national bestsellers, Anti-Democratic Inside the Right's 50-Year Plot to Control American Elections, which is new in paperback, as well as, if there's little ones in the room, plug their ears, titled Rat Fucked, Why Your Vote Doesn't Count. David's journalism appears regularly in the New Yorker, the New York Times, the Atlantic, and many other publications. You've probably seen some of it. He is also the former editor-in-chief of Salon and currently a senior fellow at FairVote National. So welcome, David.
Thanks for having me.
Absolutely. And because we wanted to make this extra special for David's tonight, I would like to welcome David Morales to the screen. David Morales has worked 3 years to pass the Washington State's Voting Rights Act as a member of the Commission for Hispanic Affairs, where he served between 2015 and 2019. David has published several articles relating to evidence issues in voting rights cases. He has also previously worked on voting rights cases at Latino Justice and the Mexican American Legal Defense Fund. In 2021, he was part of the formation of the South Central Coalition of People of Color for Redistricting, which was a community-based group that successfully sued the state of Washington to obtain VRA compliant districts here in Central Washington. David is an attorney and lives in Yakima. Welcome, David.
Hello.
Welcome, David, again. We're so grateful to have you both here today to lend your expertise about what's going on at the national level, how it might impact us here in Washington, and what we can do about it. So David Daley, I'm going to go to you first. What is the Federal Voting Rights Act of 1965? Let's just start with that and get a base of where we are.
Sounds great. Thank you, Carrie. Thank you, Elise. Grateful for all of the important work you do there. Honored to be on with David as well. And grateful for the very crucial work he does and has done. Pleasure to see so many friends and familiar names in the chat as well. The Voting Rights Act of 1965 is the most important civil rights legislation the nation has ever seen. In many ways, the Voting Rights Act is our first real step at becoming a multiracial democracy. I mean, I think that if you take the Reconstruction amendments that were passed after the Civil War and then include the Voting Rights Act after that, that in many ways, these are the documents that are the truest articulation of the ideals I think we all want this nation to live up to. The Voting Rights Act was very hard won. The Voting Rights Act was necessary because across the South and in many other parts of the nation, the Reconstruction amendments to the Constitution were not followed or honored, and indeed ignored in many ways. And there was, instead of the multiracial democracy that might have flourished after Reconstruction and the Civil War, we had nearly a century of Jim Crow instead. And it was the Voting Rights Act passed after decades and decades of hard work and civil rights organizing and fighting and overcoming violence and all kinds of obstruction that finally the nation got a look at this on a Sunday in Selma, Alabama, when John Lewis and many other foot soldiers attempted to cross the Edmund Pettus Bridge and were instead met with dogs and tear gas and clubs, were beaten within inches of their lives, and the nation recoiled in horror at what was happening, and the Voting Rights Act um, followed soon thereafter, pushed through Congress by then President Lyndon Johnson, um, and has served. And I'm sure we'll get into all of this. I would say that it served as the most crucial protection of the right to vote for all Americans ever since this Supreme Court began to take aim at it over the course of the last 13, 14 years. And now the document looks very different than it did in 1965.
Thank you for laying that out. And to that point, we're obviously going to get into how Louisiana v. Calais is somewhat of an attack on the Voting Rights Act. But this is not the first time the court has challenged the WVRA, or excuse me, the VRA, or the first time the Voting Rights Act has been challenged in the courts. What changes have been made to it up until this point?
Yeah, I think that's a really important question because we sometimes think of the nation as being on, Dr. King, spoke of an arc of the moral universe that's long and bends towards justice. And I think what's really important to understand is that the Voting Rights Act has been challenged every step of the way, almost ever since it was signed into law. Um, the first real challenge to the Voting Rights Act was filed by South Carolina in the fall of 1965. It did not take very long for Southern states to say, we don't need to be under this. This is unfair. This violates our sovereignty as states. You are singling us out for disparate and unfair treatment. We fixed these problems. And the Supreme Court, from 1966, when these cases start arriving into the 2010s, had largely, not perfectly, but had largely upheld the spirit of the Voting Rights Act. The Voting Rights Act had been reauthorized by Congress several times in the 1970s, again in the early 1980s, in the 1990s, and crucially, by a nearly unanimous Congress in 2006 for another 25 years. And during most of those reauthorizations, that the Voting Rights Act was expanded and improved upon. Some of the improvements that certainly have affected voters out west include protections that ensure that ballots are printed in multiple languages for communities that need that. Um, Most of those protections began in the 1970s. In the 1980s, you had crucial improvements that made clear that the Voting Rights Act did not require racial animus or intent to be proven when a law was passed. It simply required a disparate racial effect. In 2006, again, it came with a 14,000 page congressional investigation that documented all of the reasons why and all of the specific examples across the nation in which Section 5 preclearance, the most effective enforcement mechanism, was still necessary. So all of these reauthorizations have been vital and generally strengthened the spirit of the VRA. And then we get to the Roberts Court, in which we have unfortunately, over these last 13 years, really begun to see these crucial protections chipped away and eroded.
Absolutely. And the easiest thing I can always point to is in 2013, Shelby County v. Holder, which struck down preclearance, which you spoke to as one of the most effective ways to enforce the Voting Rights Act. And now we're facing what appears to be an attack on Section 2 of the Voting Rights Act. Section 2, of course, being what creates the legal apparatus to draw districts that are race-based. So can you speak to a little bit more about Louisiana v. Callais,
Yeah.
more than me anyways? Speak to Louisiana v.
No,
Callais,
certainly. It's a
why it's such a
complicated,
monumental case.
a
Yeah,
complicated case with a complicated history. I think the best way of explaining it simply is to, suggest that this is a case essentially about whether it is permissible to use race really at all when it comes to redistricting. And uh, this has been a very complicated issue because there have been two different sets of case law on redistricting, on partisan gerrymandering and on racial gerrymandering. Um, you know, on partisan gerrymandering, the court back in 2019 essentially closed that down in the Rucho case out of North Carolina, and said that it's a political issue beyond um, the power of the courts to resolve. I'd suggest that was a decision that incentivized much of what we're even continuing to see this summer and fall on mid-decade redistricting. But on racial gerrymandering, there have been guidelines that have been set up over the years, complicated guidelines, right? That have been clear that you can use race in order to protect the power of communities that are appropriate in number, that live in fairly compact areas, and in states in which there's still racially polarized voting. You can draw districts that ensure that communities of color have an opportunity to elect candidates of their choosing. And, in many ways, that is the only reason why many of these communities have representation at all. It would be very easy otherwise to, crack them in pieces and draw them across multiple districts. The Voting Rights Act protects those communities and ensures that they have representation. The Callais case essentially is a challenge to this. Louisiana is about 35% black. It has 6 seats in Congress, and it was required that Louisiana go ahead and draw a second um, opportunity district for voters of color to elect a candidate of their choosing. White voters in Louisiana challenged that. They said that essentially violated their constitutional rights to, elect all 6 of those districts, and have challenged the use of race in much the same way as voters have challenged the use of race in, college admissions or, affirmative action and, public education spending. And they have found a lot of success with this court that, as John Roberts said in the Louisville case about public education funding, a way to end racial discrimination, he would say, is to stop discriminating based on race. And so this case essentially has the backwards, it puts us in backwardsville because, the suggestion is that in order to, that districts that are protecting Black voters or communities of color are essentially discriminating against white voters, and that the Reconstruction amendments that are so very clearly about a race and about protecting minority voters are really being turned inside out here. And if this crucial piece of Section 2 is eviscerated, it really has the potential to wipe all of these districts across the South off the map. You could see if this case goes the wrong way, and if this case comes down in time for states to remap ahead of the 2026 election, you could see Louisiana, Alabama, Mississippi, South Carolina, Tennessee, maybe even Texas again, Florida, all jumping in with mid-decade redistricting next year that effectively silences Black voters across the South and makes it easier to do the kinds of gerrymandering that we've seen in Texas and other places that have really shattered Latino communities as well.
Absolutely. So what I'm hearing is that what's at stake if the plaintiffs are to be successful in Louisiana v. Callais is that voters of color, largely Black and Latino voters here in the United States, could potentially lose basically any semblance of representation they've been afforded through the Voting Rights Act. That's big. That's big.
It's huge. The stakes of this case are deeply consequential.
Absolutely. What would that mean for Americans and voters if they were to be successful? And how are national groups fighting to protect the Voting Rights Act?
Well, I think the representation across the South, especially, would look quite different without the Voting Rights Act. We've watched this summer, for example, right, as multiple states have moved forward on redistricting, and it's really been an unprecedented run of mid-decade redistricting. The only thing that has stopped multiple states from getting involved here is that some of these districts have been protected by the Voting Rights Act. I think it would be really easy to imagine, South Carolina or Alabama or, Tennessee joining the mix of what we've seen this summer from Missouri and North Carolina and Texas, if those districts in those states were not effectively protected by Section 2. So this would be, cataclysmic for Black and Latino representation. I think it could really reduce the number of the Congressional Black Caucus from, maybe even a dozen seats. It opens all of these states up to the possibility of additional partisan gerrymanders in such a way that I think it's really easy to imagine that most of these states would be drawn so that all of them would effectively favor white, rural, more conservative interests, and it would really push representation so far backwards that it could look a lot like it did before the Voting Rights Act existed. I mean, some states across the South went 90, 100 years without, electing anybody of color to their delegations. These communities were effectively unrepresented for decades. And it's possible to imagine that we could be turning back the clock to those times, which I think is a very discouraging thought.
I think we'd agree with that. And it's also discouraging to consider that when one group isn't represented, many groups aren't represented. And if we're only representing one group, it's a failure of an actual democracy, right? This is not e pluribus unum. This is not many voices becoming one if we're only letting one voice have a seat at the table and be part of the decision making. So it really goes against so much of what our country's ideals are and what most voters want to see. They want to see our neighbors talk to each other and reason things out without um, having to default to other methods to have their voices heard. Um, and of course, multi-member districts is a potential solution, but we'll get into that later. um, First, I want to bring on David Morales a little bit to talk about what the Voting Rights Act has meant here in Washington. And David, thank you, David Daley, thank you so much for your expertise. We're going to get confused with the Daleys here tonight, the Davids. But David Morales, what has the Voting Rights Act meant to Washingtonians?
Well, it's basically a light of hope and an opportunity to change how so many of the systems have been built over the years. So the first case really came in 1968. That was Mexican American Federation versus Yakima County. And this was a straight up Voting Rights Act violation for the administration of literacy tests to Latino voters. Um, it wasn't successful, mostly because the jury didn't believe the Mexican testimony and believe what white political officials were saying, which is a very common theme I've had in many cases. But it's there in the record books, and it's been there for a while. So in the 1970s, Congress got around to amending the Voting Rights Act, and they put in a language provision, Section 203, basically saying that if more than 5% of an electorate speaks a single language, then there is an opportunity to bring a case. And so this actually Yakima has been almost majority Latino for a very long time, but it wasn't until 2004, United States versus Yakima County, that the county was sued for failure to adhere to the language provision of the Voting Rights Act. And so since 2004, there's been a consent decree in place saying that Yakima County has to translate everything into Spanish. So if you live in Yakima, you're used to this idea that one side of the ballot is in English and then the other side of the ballot is in Spanish. There's also a special monitor in place to administer this one. Then the next case came in Montes versus City of Yakima in 2012. So this was a challenge to the at-large electoral system in the city of Yakima. This was the Voting Rights Act being used by the local community to demand that districting take place because the standard city arrangement is at-large voting every basically in staggered elections in odd years. It's not a situation that is conducive towards allowing people of color to win elections. And so that suit was successful, and then the first Latinos were elected to the city council in 2015 in the city of Yakima. And then after that, there was a WVRA that passed in 2018. So then you had the Franklin County case, and this was basically an election for both the county commissions and then the city of Pasco under the Washington State Voting Rights Act, and that ended up in a settlement. And then there was a challenge to the state Supreme Court, and the state Supreme Court agreed that the Washington State Voting Rights Act was constitutional. Then in 2020, there's another case, Aguilar versus Yakima County. This one was another one where basically they said it's a violation of the Washington State Voting Rights Act to have these at-large electoral systems at the countywide basis. And there was a Latino Opportunity District created in Lower Yakima, which is district number 3 in the county commission race. That one was very interesting because the litigants asked for ranked choice voting as a remedy in that case, and the county would not agree to it, basically. And so we ended up with the district system that we have now in Yakima County.
I remember that. I remember that.
Yes. Then Soto versus Hobbs, 2022. This was the case that was also brought by the South Central Coalition of People of Color for Redistricting. And this was after the census. We all knew that there was an opportunity to create a Latino Opportunity District in Central Washington. And the Commission on Redistricting completely failed to acknowledge that or take it seriously. And so this lawsuit was brought in order to reconfigure how those Central Washington legislative districts 13, 14, 15, 16 are handled. And so now we do have a Latino Opportunity District, which is district number, I want to say 15 in Yakima and Franklin County. So then we had the tribunal litigation followed that, basically saying that it was kind of weird, but it was basically trying to argue that it was a violation against people's rights to consider race. It didn't go anywhere, and so this is not the first time. The Montes case was also appealed, and historically, people have been making these kinds of arguments for a very long time, and they don't gain any traction. And so it's been profoundly saddening to see the Supreme Court now give it the light of day. Many of the arguments that just hadn't been successful until the very recent past.
No, thank you for walking us through the history of the National Voting Rights Act in Washington. And a couple of times I heard you mention the Washington Voting Rights Act. What is the Washington Voting Rights Act? How is it different from the Federal Voting Rights Act? And why did we need it in addition to the Federal Voting Rights Act?
Yeah, there's a very particular history here. So Texas and California have a large rural and growing Latino population in their rural areas. And that makes it strange because it means that, let's say in 1975 and 1960, what may have been a small minority population may be a majority voting age population by 1985, 1995, 2005. And so there are emerging Section 2 possibilities in many of these rural places. And so that's why MALDEF has had a long history bringing these kinds of voting rights cases in California and Texas. Now, there was a particular lawyer, Joaquim Avila, who had a difficult time winning some of the voting rights cases in California because of the amount of interference that from right-wing political groups who would engage in all kinds of shenanigans to muddy up the case and muddy up the facts, basically. So he wrote the California Voting Rights Act, and the way it's basically structured is to get around the Gingles factor. So going back to the 1980s, the Supreme Court said that you could only bring a Section 2 case if you showed intentional discrimination. Well, then the Senate overrode them and said, no, the effects-based test is good enough. But then they added the Gingles factors. And so there's these whole list of things that you have to go through to weigh and consider whether or not a minority population has a claim. And so those Gingles factors, after a while, ended up having a serious bite of the cases. And so the idea was basically to remove them, to make it simpler, to go back to what the effects-based test was in the late 1960s and 70s. And so the idea was, if you can show dilution through polarized voting, that the minority population can be the majority of a single member district, or even in the case of the California and Washington State Voting Rights Act, doesn't even have to be a majority of a single member district. It just has to be a district that does allow the minority to elect a candidate of their choice, then you could win the case without a lot of other evidence needing to be shown. And so that's what was passed in the state of California. And then Joaquin Avila became a professor at Seattle University Law School. And so what happened was he proposed the same law again for the state of Washington. And so it was pretty much tied up in the legislature for many, 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 I mean, many, many, many years. Um, the
That
Republicans had a
doesn't
majority
that
for
doesn't
the
sound like our legislature. I don't know.
Well, the Republicans had a majority in the middle of the 2010s, if you don't remember, in the state Senate. And so it wasn't actually until around 2017 that the law passed. And so it became the 2018 Washington State Voting Rights Act. And then since then, it's been strengthened by HB 1048, which also allowed some additional remedies to be put in place. But yeah, that's the history of why we have the Washington State Voting Rights Act.
Very cool. And it sounds like it's been used in a similar way to the Voting Rights Act of 1965 to pursue ensuring that communities of color have accurate representation, at least on their ballots, and have the opportunity to elect representation to their bodies of governance.
Yes,
Which is
Pasco, Franklin County Commissioners, Yakima County Commissioners, Sunnyside City, Sunnyside School District, all are right now pursuing and are electing people of color to all kinds of local offices because of the Washington State Voting Rights Act.
very cool. We love to see legal cases being put to use to help people. If Louisiana v. Callais goes through as the plaintiffs are hoping it will, how might that impact the Washington Voting Rights Act, if at all, and how will it impact Washington State in general?
Yeah, there's kind of four possibilities. One possibility is it's a nothing burger and the Supreme Court upholds the law. We've seen that a lot, for the last 15 years. On Section 2 cases, it's always the end of the world, and then the Supreme Court upholds the law. Okay, now things have gotten a little bit out of hand in the last 4 or 5 years, and so that's not something you could rely on anymore. The other option is the Supreme Court upholds political considerations or partisanship as a traditional redistricting criteria. That would be very difficult because it would basically mean that whatever was decided by the legislature or whatever was decided by the political mechanism would be upheld, and you would need basically to demonstrate a district or demonstrate a solution that still upheld the same level of partisanship. So, for example, that would be lethal to the case in 2022, the Soto Palmer case, where you had the Republicans and the Democrats voting for a particular map that balanced or kept the same number of Republicans and Democrats in the state Senate and the state legislature. The other option would be race may not be used as a consideration in the remedies. So some justices were throwing that one out. That would be also terrifying because it would mean we would be in the blind universe. Now, I've created maps, like, in Texas, I created a map using HEB, basically grocery stores, to link and to demonstrate where a low-income population lives and where a higher income population lives. But it would be almost impossible, not impossible, but almost impossible in many instances to demonstrate remedies that could work if you don't use race. And then the last one is, throwing out the Section 2 altogether, and basically abrogating the U.S. Constitution, the 14th and the 15th Amendment, but I wouldn't put that past them. So any of those options would be horrifying. How they would affect, I mean, the Washington State's Supreme Court has has upheld the Washington State Voting Rights Act, but any law would need to be interpreted to be in line with how the US Constitution is interpreted. And so it will definitely put some limitations on litigants. Like it's not the case that a Supreme Court decision would not affect the Washington State Voting Rights Act, because it will.
Absolutely. What tools does Washington State have to keep our voting rights strong? Because we had the same take, we understood it the same way, that if Section 2 is eradicated more or less, of course it's going to have impact on lower courts.
Yeah, there's several
I've-
things.
yeah.
One of the elements that we've been talking about locally in Yakima has been retrogression protections. So many of the cases that have been won either by the state or by the Federal Voting Rights Act, there's been immediate pushback to redo all that and throw out the manner of government and do all kinds of things that would retrogress the situation. And so there are different ways you could create state protections against retrogression that would be very similar to the old Section 5 of the Voting Rights Act. The other one is redistricting. I mean, the fact that our redistricting commission basically ignored the rights of people of color is highly troubling, but also very much in line with how it was created, which is it wasn't a nonpartisan redistricting, it was a bipartisan redistricting. And the difference is in bipartisan, it means the Democrats and the Republicans work it out amongst themselves. And that is very different. It's an almost purely political process, and not one that tries to appeal to any higher standards. So we'll see. I mean, options include allowing different kinds of remedies, such as the multi-member districts or multi-choice districts for like what you guys are advocating for as an organization. There's different types of things that could be drawn up, but it would really depend on how the Supreme Court rules. And we think about how we need to be fixing our elections moving forward.
Absolutely, because as we are seeing in current time with these national gerrymandering wars, if that comes home to roost, it's a battle nobody wins. It's just a back and forth. And so having a solution like a multi-member district using ranked choice voting to decide our wins could have a really monumental impact. And I'd be happy to hear more from either of you about that. But yeah, it isn't a remedy we're advocating for, because at the end of the day, redrawing lines can be redrawn again, and we're seeing that.
They can. And I think in the Yakima County example is also a little bit wobbly because that hasn't elected a Latino county commissioner.
Right.
It's the Republicans have found ways of winning it through, and much of it has to do with how the social economics impact, where the difference between where Latino voters are versus where the Latino population is distinct enough to make the districts much less viable. And so that ends up having a profoundly negative consequence. And so I think in the county commissioner's race, you could definitely see examples of where there are definitely viable candidates who would have won had they been in different districts.
That makes a lot of sense. And it reminds me of our neighbors to the south, Portland, Oregon, using multi-member and multi-winner districts for the first time for their city council. And there's a whole neighborhood that had never had representation on their city council before, and now does have representation from racial minorities and socioeconomic minorities. So we know it can work, which is very exciting. And there's, of course, work to do ahead. So we have some questions from the audience here that I'd like to move into, if that's all right. unless either of you have more to say on what we've been talking about first.
I'm happy to jump into multi-member districts for just a second,
Yeah,
especially for
please do.
Congress, because, I mean, I think what we are watching right now as this unprecedented mid-decade gerrymander Armageddon unfolds is that the only thing that really matters is the power to draw lines, and then you have the ability to really pick winners and losers. And if this court does do away, especially with Section 2 in Calais, it opens up a situation in which it's really open season, and there would be nothing left to stop politicians of one side from essentially cracking communities in order to draw themselves maps on which they take all of the seats. We already have a winner-take-all system, but we're about to have winner-take-all states. You could have even 50-50 states, right? In which if one party has locked themselves in office, they could still continue to draw themselves all of the seats, right? We're watching this unfold in North Carolina. A pretty evenly balanced state politically, right? A Democratic governor. It goes Republican at the presidential level most recently. But very close in all of these races, and they have just turned a 10-4 congressional a delegation, already a gerrymander, even a deeper gerrymander now at 11-3. So if you instead took a state that had, let's say six congressional districts, and if you drew two equal districts of 3 and 3, you have to draw them equally as far as population. You would have an independent commission draw that line, a truly independent commission, not a bipartisan commission doing this for political reasons. But the studies on this show that almost no matter where you draw the line, what you get are districts that can't be gerrymandered. Larger multi-member districts, it almost doesn't matter where the line goes, because you have the power to elect somebody with a lower threshold. You see Democrats, you see Republicans, you might even see independents win every place. Every district in the country becomes a swing district, electing people of all different political stripes. It puts an end to this idea that, in single member districts that are so non-competitive, the only race that matters is the partisan primary, which everybody races all the way to the left or the right to win. In states that don't have ranked choice voting, right, you might have 12 or 15 people in that race, and you can win the partisan primary with 18-20% of the vote. That's happened here in Massachusetts. And then you coast into office, having been chosen by a fraction of the people, and you're only accountable to a fraction of the people because you can't be beaten. And this would go a long way as well if the court destroys a Section 2 towards ensuring a representation for communities of color. Because if you can, you can't crack and pack in a multi-member district in the same way. If you have communities that vote cohesively for a candidate of their own choosing, in most cases, what you're going to find is that they're able to elect. So in many ways, multi-member districts would be a protection against the U.S. Supreme Court and partisan gerrymanderers everywhere trying to take the power away from all of us voters to choose our representatives and to hand it over to map makers.
Thank you so much for speaking to that. Yeah, go ahead, David
One
Morales.
last thing. The Washington State Voting Rights Act does not apply to congressional district. It does not apply to the state legislature, and it doesn't apply to judicial districts. And so there's only so much that can be done. It's basically city, county, and school board levels, and that is a major fix that needs to be worked on, because if we lose the Voting Rights Act, then we have no tools to deal with those other higher level districts.
Absolutely. I actually didn't know that about our state legislature or the all of the races it does not impact. So thank you so much for that. There's a question from one of our audience members, Maya, who thanks you both for all of your work. And she's wondering, how do we move forward on a state level no matter what happens with the SCOTUS decision? Do we have a path forward? Can we update the WVRA? I know Representative Mena had introduced the WVRA 3.0 recently. Does that include protections at more levels, or what else can we do here?
I mean, maybe I'm not familiar with the 3.0, so I have to take a look at it.
Fair enough, fair enough. Do you know of any other legal remedies we have here in Washington to protect ourselves at the state level or the judicial level should Section 2 be eradicated?
No.
That's a tough pill to swallow.
Mm.
Yeah. Yeah, thank you. Thank you for your candid answers. Multi-member districts are absolutely the sort of North Star of FairVote Washington. We, amongst having better representation and lowering the temperature of politics and electing people who are actually representative of their communities, we also see it as a way to reduce political violence. We point to the work Northern Ireland has done as a way to compare politics. Many of us here will remember the Troubles, or at least know the name. The Troubles was solved. That Good Friday Agreement actually was installing ranked choice voting and proportional representation. That was how the Troubles were ended, was ensuring that every political stripe had an opportunity to have representation and that they could work together. And they were forced to work together. And that environment creates an entirely different one than we're experiencing now, where it is winner take all, loser gets none, and where voters are often left feeling that their vote doesn't matter. That wasn't the point of a representative democracy, and we hope we can pull this from the brink. We would, of course, like to be wrong about Section 2 being damaged at the level that it is, but in case we're not, it's good to know what's ahead and how to prepare. With just a couple minutes left, David Daley, could I invite you to explain multi-member districts again? We have a question from the audience.
Sure.
Yeah.
Right now, states for state legislature, also for members of Congress, we draw districts that elect one person. And so when that is the case, there is an election in that district, and the winner moves on, and the loser goes home. Those districts give an awful lot of power to the map maker, especially these days, in which there's so much technology, so much data available. How you draw those district lines can really determine winners and losers. That's the essence of partisan gerrymandering. So if you want to put an end to that, some states have gone the route of independent commissions. Those are effective in some places. They can also still be affected by politics, especially when the commissions are not truly independent. But they also don't change the nature of winner take all. And I think an example, is my state of Massachusetts. Plenty of Republicans here in Massachusetts, but we have a 9-0 delegation, not because the state has been gerrymandered, simply because of how people live and the geography of the state. It's a 65-35 state. If you wanted to draw a Republican district, it would have to be the craziest thing you've ever seen. But if you had 3 multi-member districts, of 3 members each instead of 9 single member seats. Each of those districts would likely elect 2 Democrats and 1 Republican. You would get proportionality out of a delegation that actually matches the political breakdown of a state. Tennessee, which right now is an 8-1 Republican map, it's not an 88% a red state. If you drew 3 districts of 3 in Tennessee, you would probably also wind up with a 6-3 state. And so what this does, right, is it allows everybody to vote in a race that matters. It allows everybody in a district to feel like there is at least someone who is likely to listen to them. It allows all of us to vote in a congressional race that actually feels meaningful. I'm 55 years old. I've never voted in a congressional race that's actually meaningful. I think all of them have been 100% lopsided affairs in which the winner had been known for 9 months or maybe 2 years going into, that election. But what it also does is it changes the incentives, I mean, when you are accountable to more voters, when when you're not accountable only to a small sliver of a primary audience, you behave differently. You get different kinds of people. I mean, I just think our Congress, in the same way you talk about turning down the heat, I think our Congress would work better if we had some Republicans from New England who are, a different breed, perhaps. If you had some Democrats from Tennessee and Oklahoma and Kansas and Nebraska, um, maybe you'd have a Congress that actually had bridge builders in it again and some folks who are able to work together if they were incentivized and elected in a different way. Things are bad enough right now that there's not much to lose by giving this a shot.
Would have to agree. Thank you for going over that again. Um, I thought that was going to be our last audience question, but 2 quick things. First, I have learned that the Senate voted to end the shutdown while we've been talking. It does still need to be passed in the House, but we wanted to give that update quickly here. And we have an audience question wondering if we have an idea of when Louisiana v. Callais will be finalized, when it will be heard and had a decision made.
The case was heard the middle of October. The court tends to hand down its big decisions the last week of June, but it doesn't have to. And the court in this case, which is a complicated one, because it's a case that they'd heard last year, but they are re-argued and rebriefed on the bigger constitutional questions. They often put those cases early in the term because they want to decide them quicker. And if the court wants to issue this decision in a way that allows states to draw lines ahead of the next election, I imagine what you would see is a decision late January, perhaps early February. And then it would have to be up to individual states if they wanted to move forward, what their deadlines are in each of those states for solidifying maps. To me, the real comparison here is the Citizens United decision, which was also ordered, re-argued, and rebriefed along the bigger constitutional lines. They heard that a case very early in the 2009 session, and they came out with the decision at the end of January of 2010. So I don't think it's impossible if this court is interested in having this decision come out in time to affect the 2026 elections, that they couldn't do it. It's certainly in their power if they would like to.
Well, thank you for that insider information. It feels a little insider baseball. Appreciate it. We are over time now, so I want to thank both of you so much, both Davids here. We'll do a little round of applause. Thank you so much for your expertise, your willingness to share it with us. David Daley is on the East Coast. It is, well, it'd be past my bedtime if I were if I were you. So thank you for staying up late for us. And we're just so appreciative. And for everyone, we hope you have a nice Veterans Day tomorrow. We thank everyone who has served. We're appreciative of it. So thank you again. And if you have more questions, please feel free to email them to us. We're at info@fairvotewa.org. And we'd love to hear from you. So thank you, thank you, thank you. All right. Happy Monday, everyone.
Good night.
Good night.
Good night. Thank you.